Let's cross over to the Supreme Court, where the five-judge bench is currently giving a ruling on the retirement age of judges. Remember, this is a story that we have been focusing on for you for the last couple of days. Let's cross over and listen in just a little bit.
And impartiality is compromised. The preliminary objection raises issues of constitutional interpretation, which this court must address. It is on this basis that he argued that all the members of the bench must disqualify themselves, and that if they do, there will be no court to decide the applications. Mr. Noroji has contended that the procedure employed by Mr. Mutata is unheard in law, and that the court cannot be divested of its mandate summarily by means of a purported preliminary objection. I've looked at earlier on I had addressed myself to this case of Mukisa Biscuit and Company, okay? And I need not do so here, but before I begin, it's necessary to make some observations. When adopting cases decided in the pre-2010 constitutional dispensation, sight should not be lost of the fact that they should be viewed and understood through the constitutional lens. In other words, they should be infused and baptized with the spirit, letter, and the overall vision of the Constitution. An approach that pays homage to the principles of equity, fairness, integrity, inclusiveness, transparency, accountability as enunciated in Article 10 should be preferred over a pure legalistic one. And I think in the case of Aramat, and I quote it here, in one of the paragraphs, we said that the Supreme Court resides not in the more constrained position in which the Court of Appeal had been at the time of Lillian S. I've already stated that Mr. Mutata's preliminary objection is not anchored on jurisdiction, although it's labeled as such. Does that qualify it as a preliminary objection? And, you know, I go back to Mukisa Biscuit and quote Wilkinson in Expert Pinochet, Ugarte number 2, and look at the Jaspi Singh case that, you know, has also been quoted, and which is our decision. Do Mr. Mutata's allegations of bias fall under the category which calls for disqualification without the need to investigate any facts? Only when the answer is in the affirmative can the ground of bias bring preliminary objection under Mukisa Biscuit. I say it is indisputable that the facts relied on by Mr. Mutata need not be investigated. They are not disputed, they are hard, clear, and recorded. Wanjala, CSJ, and I sit in the Judicial Service Commission, a part in these proceedings, which made a decision that judges should retire at the age of 70 years. This is a fact which even this court may take judicial notice of. We have participated in that decision of a corporate body, the JSC. Now, can we sit on a bench where the JSC is seeking an order declaring that judges should retire at the age of 70 without raising a perception of bias or partiality? I think no. The position of my other colleagues is also similar. Judge Ojwang and Judge Njoki, with Rawal, DCJ, and Tunoi, Judge of the Supreme Court included, expressed their views in relation to this question before us now in Salat. And that is the paragraph that Omutata quoted. I don't need to read it. Mr. Omutata relied on the above passage to assert that to allow the said judges to sit on this matter might raise a perception of bias. Counsel for the applicants contended that those are not findings. I'm not convinced. The above paragraph is very clear on which position the judges are